this nice introduction. It's fit and proper, I think, that I should give this talk today on the 8th of March, the International Women's Day, which incidentally is a public holiday in Berlin, the only federal state in the country where this is a public holiday. And I think it will be pretty clear to all of you, and certainly at the end of my talk, why this is a fitting date for my talk. I would like to talk a little bit about a program of research that I've been conducting for a long time, namely to ask how rape myths and stereotypes shape responses to sexual assault. Okay, now how do I move this on? I don't know why it won't.
Is it, sometimes it can,
Right.
yeah,
It's
okay, you got it,
now.
okay.
Sorry, sometimes it's a bit slow on the uptake. Yes, I would like to begin by asking why rape myths and stereotypes are a topic for aggression researchers. And I think there are a number of reasons why this is important for us as a group of aggression researchers to look at this issue. Rape myths and stereotypes are often causes for victims to feel victimized again, secondary victimization by the reactions of the person's social environment to an experience, a primary experience of sexual victimization. I also want to argue and show some data that this kind of secondary victimization actually creates a vicious cycle of stereotyping, in the sense that stereotypes about rape affect survivors, victims' willingness to report and legal decisions, which results in a select number and type of cases to come to the legal system. And the legal decisions in these cases then inform public attitudes. They make certain types of sexual assault appear the normal case, so to speak, which may have very little to do with the reality of sexual assault. And so the stereotypes affect legal decisions, and legal decisions then feed back into the stereotypes. Rape myths and stereotypes create a climate of tolerance of sexual aggression, minimalize sexual aggression, trivialize it. They undermine victims' acknowledgement of sexual aggression, their willingness to report. They are also held responsible for low conviction rates in rape cases. And in combination, I think it's fair to say that they create a justice gap for victims of sexual assault. It's important, I think, to be reminded at the beginning that sexual assault is a social construction. It's a legal category, but it's also a social construction based on social consensus. We've seen this very recently in the Me Too movement, where consensus about what is acceptable male behavior towards women was challenged and still is. The recognition of marital rape as a relatively recent development in the Western world, and by no means universally accepted worldwide. And the stereotypes and myths about sexual assault that surround sexual violence are part of this social construction. And I would like to look a bit more closely at three aspects of this kind of stereotyping, three different stereotypes. There are lots more, but these are the ones that are most widely researched. One is the real rape stereotype that I'm sure you're all familiar with, that a real rape is characterized by an attack by a stranger who uses physical force against a victim who strongly resists in physical terms. And anything that deviates from this stereotypical description of what is a real rape is then perceived as not real rape. And there are loads and loads of studies showing that the more a specific case deviates from this stereotype, the more victims are blamed and the lower the perception of the perpetrator's blame or responsibility. So the circumstances of an assault which don't play a role in the legal definition of rape are very critical for people to decide whether an alleged incident of sexual assault is actually a rape. Then there is the real victim stereotype. The victim has to show physical resistance. Real victims report immediately and not just after several weeks. And of course, there's also a stereotypic assumption about the type of person the victim is. My very first study in this area, and you can see that I go back quite a long time, took a short video from one of those real crime programs where the audience is supposed to help with the identification of suspects. And I took this video of a woman who was raped by a man whom she gave a lift, a stranger, with the back to the camera. And the only thing we varied in our experiment is whether we presented the victim as a teacher or a school teacher or a shop assistant. And she was blamed significantly more when she was portrayed as a shop assistant as compared to a teacher. And in a later study, the only thing we manipulated was what the victim had done prior to walking back to her car on the car park where she was attacked and raped. And again, the victim who had sat in a bar prior to the attack was blamed more. Then there is the credible witness stereotype, which is particularly difficult. And there's, again, a large body of research showing that lay people, jurors, but also police officers, judges, have clear ideas about what a credible witness looks like when she talks about her attack. The stereotype expects victims to be emotionally upset, to be distraught, to suffer visibly. And if they come across as rational, as calm, then they cannot be credible witnesses. And at the same time, being a credible witness makes an emotionally agitated witness an unreliable witness. So in a way, victims cannot get it right according to this logic. Just to give you an idea about the various contents of these rape stereotypes, I thought I would show you a few items from one of several measures of rape myths. And rape myths are defined here as descriptive or prescriptive beliefs about sexual aggression that serve to deny, downplay, or justify sexually aggressive behavior that men commit against women. So they are myths in the sense that they are overgeneralization, they are factually incorrect. There are a number of different aspects to defining a statement or a belief as a myth. And you can see here just a few items from the AMSA scale developed in Bielefeld by Gerd Bohner and his colleagues. And that's a measure that we have used a lot in our research. Right. What is the role of rape stereotypes in legal decision-making? This is going to be an aspect that I would like to zoom in on in my talk today. And before we go specifically into the findings that I want to show you, I think it's worth thinking a little bit about the type of judgment that are prescriptively required in legal decision-making. Legal systems, at least in some countries that I know a little bit about, have recognized the potentially harmful role of biases in legal processing of rape and sexual assault complaints as a possible cause of the high attrition rates. And I will talk about attrition in a minute. And when you look at legal decision-making from a social cognitive point of view, we can draw on a distinction that the psychologists among you will be familiar with, and that's the distinction between data-driven and schema-driven information processing. Data-driven processing operates on the basis of the specific information at hand about the judgment to be made, whereas schema-driven information processing is a kind of top-down process looking at starting from generalized ideas about a situation or about a person or an event, and then applies this general perception to the case at hand. And legal decision-making should be data-driven, based on the facts and the evidence and they should not be in a way infiltrated by considerations that are part of more generalized conceptions about sexual assault, such as rape myths and stereotypes. So I think one can argue that to the extent that schema-driven processing is applied to judgments about legal cases, this is a violation of this normative definition of data-driven processing. At the same time, there can be no doubt that cognitive schema-driven information processing it does affect legal decision-making, especially in sexual assault cases. There's a lot of evidence showing such impact of rape scripts and schemata on legal decision-making, and that is clearly a problem. We also know from social cognition research that there are certain conditions under which people are more likely to rely on their cognitive schemata rather than analyze the data at hand. And two critical conditions of schematic processing are first, when the evidence is ambiguous, when we don't have proper or enough data to make a data-driven decision. Then we refer to our generalized stereotypes and schemata. And the second condition is when a certain stereotype is linked to the judgment that one is supposed to make. When the decision to be made is highly or closely linked to the stereotype. And because these stereotypes are so widely shared, this second condition is also typically present in judgments about rape cases. There is evidence, this is an early study some years ago about what people believe in terms of victim blame, an Amnesty International report, but it would be easy to dig up more recent surveys which also show the kind of stereotypic assumptions about victim blaming that are prevalent in many societies. Now, against this background, we have been running a number of studies over the years, and I was pleased to see that some of my co-authors are present here tonight. And the purpose of the studies was that we wanted to show that judgments about rape are affected by cognitive schemata in lay people as well as in law students and lawyers. We wanted to show that the link between rape-related schemata and judgments about rape is stronger in cases that do not match the real rape stereotype, and that these rape-related schemata and stereotypes also affect people who have legal training and should be committed to a data-driven processing of rape complaints. And we also wanted to go one step further and think about possible ways of suppressing the role or reducing the influence of schematic processing in legal decision-making. I already mentioned that rape is a problem that the attrition in rape cases has long been recognized as a problem, and attrition happens at sequentially at several steps in the process. It happens at the first step of victims' responses, in the sense that victims are influenced by rape stereotypes and myths in acknowledging that what they experienced was actually a rape or a sexual assault. And they are influenced by rape stereotypes in their decision to report, because they anticipate that others will blame them for what happened to them, especially when it's not a so-called real rape. Attrition also happens at the police and prosecutor stage when they evaluate victim reports and behavior. I will say more about that in a moment. The decision to refer a case by the police, the decision by the police to refer a case to the prosecutors is affected by rape stereotypes, in the sense that the closer a specific case is to the real rape stereotype, the greater the chances of police deciding that there is enough evidence to hand it over to the prosecution. And then the prosecution has to decide which cases to bring to court. And again, the more real in the sense of the stereotype a case, the more likely it is to actually go to court. And once a case is at the court stage, there are jurors and judges' responses. They have to assess victim credibility, and they have to decide to convict or acquit in the sense of case of jurors or judges, depending on the legal system. And at each of these stages, stereotypes about rape come into play and lead to cases being, in a way, unselected from the system and never make it to a trial. At the acknowledgement stage, I just want to present two findings here to you. There is a meta-analysis of the literature on unacknowledged rape, and over the entire set of studies, 60% of female victims did not acknowledge rape. This needs to be not acknowledged, not unacknowledged rape. And we did a study recently in which we found that 60% of our female and 70% of our male victims did not acknowledge their sexual assault. And we identified them on the basis of behaviorally specific questions, and then asked them, have you ever been sexually assaulted? And the unacknowledged victims are the ones who report an experience to the behaviorally specific questions, but say no to the question of whether or not they've ever been assaulted. At the reporting stage, again, I think this is widely known. Only a small minority of sexual assaults are disclosed to others and reported to the police. The latest representative data we have for Germany show that 15% of victims reported to the police. A more recent paper from the US shows the reporting rate of just under 25%. And it's also been shown that victims who accept rape myths are less likely to report, especially if their experience doesn't match the real rape stereotype. And when you do qualitative studies about barriers to reporting, fear of disbelief by criminal justice agents, it always comes pretty high up on the list of reasons for not reporting. So what are the effects of rape stereotypes on judgments about victims, perpetrators, and sentences? There are lots of studies with community and college students, and they have consistently found evidence of schematic processing. More victim blame in acquaintance and partner rape than in stranger rape. More victim blame, the less respectable the victim. More victim blame, the more perceivers endorse rape myths. And interestingly, victim and perpetrator blame are typically inversely related. So if you blame the victim, that automatically distracts responsibility or blame from the perpetrator, which is not logically cogent, because these two dimensions could vary independently, but in terms of the psychologic, they are closely related. Evidence is less consistent regarding gender differences. Maybe we have time for that in the discussion. I won't elaborate on that in my talk. And many studies find a higher tendency to blame the victim among men than among women, but other studies don't find a gender difference. It's also been argued that the motives for victim blame differ for men and women. Men show solidarity with male perpetrators. Women distance themselves from victims because that reduces their own fear of rape. That's basically the argument. And our findings have shown that attitudes, rape-related attitudes, may be more relevant than gender in explaining differences in rape judgments. I want to start by showing you our most recent study from Iran to show that in the general population, rape stereotypes are widely shared. We had a vignette study with 2 rape scenarios, one depicting a marital rape, one depicting an acquaintance rape, and as dependent measures, we had the likelihood of victim derogation, the likelihood that the incident is rape, and the suggested punishment, and adherence to honor norms was included as a moderator. What you can see here is the victim derogation measure. We find a main effect of victim-perpetrator relationship in that the married victim is blamed more than the date rape victim. One could perhaps relate this to the finding, or the idea that the marriage license is a sex license in a way, and the marital rape victim is to blame more. And in terms of how certain participants were that the incident described in the vignette was a rape, there is a significant, there's also first a main effect of marriage versus date, but it's moderated by gender in the sense that the difference between the married and the date incident being seen as rape is larger for men than for women. And the higher or the more individuals endorse the code of honor, in which male honor is violated by female family members, sexual victimization, the more these honor norms are endorsed, the more negative the evaluation of the marriage rape case relative to the date rape case. So that's begs the question, is rape a special case, or would we find a similar influence of stereotypes and beliefs with regard to other criminal offenses? Attrition is, of course, always a fact with other offenses as well. Not all cases that are reported to the police go to court, and not all court cases end in a conviction. So you could argue that rape is no different from other types of criminal offenses in this regard. We ran a study comparing rape and robbery, and wanted to test whether this circumstantial information about the use of coercive strategy, which in the legal definition is not differentiated, certainly not in Germany, but not in the UK either. Whether information about the coercive strategy used by the perpetrator would affect perpetrator blame and victim blame. And as you can see clearly here, this whether a perpetrator uses force or alcohol makes no difference in perpetrator blame and victim blame in cases of robbery, but it makes a big difference in terms of rape, with the alcohol-related victim blamed more and perpetrator blamed less than the incident where force was used. Similarly, in terms of victim-perpetrator relationship, there is nothing in the legal definition of sexual assault that refers to the relationship between the victim and the perpetrator. So this, again, is not, in terms of data-driven processes, should not make any difference. And again, the data clearly show for robbery, it doesn't make a difference. In terms of perpetrator blame, for rape, it makes a big difference. The perpetrator is blamed substantially less when it's an ex-partner case as compared to a stranger rape or an acquaintance rape. And the victim is blamed essentially more when it's an ex-partner rape than when it's an acquaintance or a stranger rape. Also, to try and compare different offenses, I've extracted here some figures from the European Sourcebook of Crime and Criminal Justice Statistics to calculate the proportion of offenders or the proportion of convictions as a percentage of offenders. And they, again, you can see that for robbery, but also for aggravated bodily injury, the proportion of convicted offenders is substantially higher than for rape. So these offenses do differ. Just briefly to show you a study we did with police officers in Berlin, asking them to describe a prototypical type of rape in comparison to a credible or dubious or hard to cope with, easy to cope with rape case or a false complaint. And the police officers then, from a list of potential characteristics, selected the ones that were that applied to these different types of rape. And again, you can see here that there is overlap between the typical rape and the false rape complaint. I'm just seeing that I'm running a little bit behind in time. That's why you can see some of the slides when they are uploaded. I want to move to a second study we ran with trainee lawyers in Germany with a first degree in law, where we measured rape myth acceptance as an individual difference variable. Again, had 6 rape scenarios varying in terms of victim-perpetrator relationship, strangers, acquaintances, or ex-partners, and coercive strategies. And we thought in this case maybe the recurrence to rape stereotype is a result of not being sufficiently knowledgeable about the law of rape. It's not covered in the law curriculum in German law courses, and if people don't have factual information, what else should they do than refer to their stereotypes? So in this study, half of the participants received the legal definition of rape prior to seeing the scenarios and making their judgments, and the other half did not receive this information. And we looked at victim blame, defendant liability, and recommended sentences. Again, we find that prior relationship makes a big difference, more victim blame in the acquaintance and ex-partner rapes, and also more victim blame when the perpetrator exploited the victim's inability to resist due to alcohol, as opposed to using force. Defendant liability shows the mirror image, less defendant liability when the victim was an acquaintance or an ex-partner, and also less when the coercive strategy was exploiting the incapacitated state as opposed to the use of force. For rape myth acceptance, we find that the higher the rape myth acceptance, or rather that only people very low on rape myth acceptance have high ratings of perpetrator blame and lower level of victim blame. And for the recommended sentence, you can see here quite well that the recommended sentence is lower in the alcohol related cases than in the force-related cases, but for an ex-partner rape, this difference is not apparent in these findings. That's the critical finding at the end. Whether or not participants receive the legal definition of rape prior to reading the scenarios makes absolutely no difference. You don't need statistical tests to see that. And so we can rule out that a lack of information about the legal definition was critical for this pattern of findings. In a study conducted in the UK, we wanted to look specifically at the possibility that the order of presentation, whether people look at or respond to the rape myth measure prior to seeing the scenarios or afterwards, would make a difference. Because if rape myth acceptance is supposed to have a causal impact on case-related judgments, the association of rape myth acceptance and judgments about the rape cases should be higher if the rape myths are made salient prior to the scenarios. We find the usual pattern of victim blaming, of perpetrator liability and length of sentence. Not much new here. There's always the same kind of hierarchy in terms of how serious these cases are perceived. In the order of presentation, we used a slightly different construct here. Female precipitation beliefs, that's one core aspect of rape myths, the idea that women precipitate rape. We did not find a significant difference on perpetrator liability or recommended sentences, but a significant difference in the correlations between victim blame and the rape myth acceptance measure when it was presented first as opposed to last. So this indicates that the impact of rape myths is stronger when they are made salient prior to looking at specific case information. Okay, where do we go from here? What are the implications of these data? First of all, the goal, in my view, is to improve the quality of decision-making by improving or promoting data-driven processing. It's not, the primary goal is not to increase conviction rates, even though it is very likely that by improving the quality of decision-making, conviction rates will go up. And we have to think about the stage at which different measures may or may not be successful. One strategy at the acknowledging and reporting stage would be to promote public awareness, and the Me Too campaign is a typical and a good example of an approach that raises awareness. Another approach, which I will look at more closely, are public information campaigns in the form of posters and so on. And at the legal decision-making stage, possible strategies to improve the quality of legal decisions is rape shield legislation, the idea that certain types of information have to be banned from rape trials, education about the law, legal professionals or jurors, and that's also something we looked at, increasing the accountability of decision makers. And just a few ideas about and findings about these different things. First of all, creating awareness. In a recent study I did with my colleagues from Switzerland, we looked at whether reminding participants of the Me Too movement would reduce the tendency to blame the victim and increase ratings of perpetrator responsibility. And they gave a text about Me Too versus a control text. And as you can see, there's no difference. So at least in this experiment, raising awareness by reminding participants of Me Too had no effect. There were other significant differences, which I won't talk about here. So the study was not only about null results, but in this important aspect, we found no effect. The second possibility to raise awareness is through poster campaigns, and I want to briefly summarize a study we ran a while ago, my British colleague Jennifer Temkin and myself, to evaluate a Home Office poster campaign that was aimed to reduce the incidence of rape by highlighting the importance of consent, to reduce the number of offenses, increase important reporting rates, and do all the right things, basically, to reduce the attrition rate in rape. These were the two posters that were used in the campaign, and we selected these posters for our evaluation study. And reasoned that if the posters were effective in highlighting consent, they should make perceivers more attentive to information that sexual intercourse took place despite the woman's expressed non-consent when confronted with a rape description. Therefore, they should hold the defendant more liable and recommend harsher sentences compared to a control condition. And because posters address what in persuasion research is described as the peripheral route of information processing, where people don't pay that much attention, we also included a condition in which we promoted more systematic or central route processing based on content and information about sexual assault. So both priming and persuasive communication are approaches from social cognition research that we refer to in this study. So we presented the two posters as primed while our participants read the rape scenarios that we took from previous research. And we tested the condition in which they saw the posters against a control condition without the posters, a combination of posters and a written paragraph emphasizing consent to promote the central route of information processing, And we also had a condition where we presented the consent information without the posters. And the dependent variables were the likelihood of defendant criminal liability in our different scenarios and the recommended sentence. I'm not going to read this out to you. This is the consent paragraph that people saw, which was taken more or less verbatim from the legal definition of rape in the UK, a consent-based definition. So they read that if they were in that condition, and whilst they were reading it, and also whilst they read the scenarios, the posters in the poster condition were always in sight on one part of the screen. And we again varied defendant-complainant relationship and coercive strategy. Okay, so large sample of from the general public in the UK, aged 18 to 69, that was chosen because it's the age bracket where people are eligible for jury service in England and Wales. As I said, in the poster condition, the posters were always inside, and in the consent condition, the paragraph was also inside. So this is the finding. It's, I think, easy to take in what we found. We found basically that the conditions made no difference to perpetrator liability, with one exception. The prison poster with the men on the bunk bed led to significantly lower perceived perpetrator liability in our rape scenarios, which is just the opposite of what the campaign intended. For recommended sentences, it's again easy to see there's no effect. It doesn't matter what people saw, the posters or the posters plus the consent paragraph, or the paragraph only, or the control condition that saw none of this. What else did we find? We didn't find an interaction of the poster presentations and rape-related attitudes, or an interaction of the posters with features of the scenarios, victim-perpetrator relationship, or coercive strategy. And the implication is that not all is well that is meant well, that the visual campaign material was not properly piloted. It turned out that we did some qualitative data collection, that participants thought the prison poster was about rape in prison and didn't take on board the message of the poster, and that we need a better theoretical grounding of such campaigns in what we know about persuasion and attitude change. Another possibility we tried in one of our experimental studies was an accountability instruction, which was that in one group of our participants, we told them that they would later be asked to defend their judgments about the rape scenarios that we gave them in public, in class. This was a class-based study, and participants in the accountability condition expected that they would have to justify their judgments on our measures later on. And we know from social cognition research that accountability promotes data-driven processes. Main findings you can see here. And we had a three-way interaction of accountability, victim-perpetrator relation, and rape myth acceptance. And in the no accountability, the standard condition, we see that perpetrator blame is substantially reduced amongst participants who score high in female precipitation beliefs. This low rating of perpetrator blame in this particular constellation, high rape myth acceptance, and an ex-partner rape, this disappeared in the accountability condition on the right-hand side. So that was at least a small positive effect or intended effect of the accountability instruction. And conversely, for the ratings of victim blame and the no accountability condition, we find this typical result that people who believe in rape myth blame the victim in particular when she was raped by an ex-partner. And again, when people held accountable or expect to be held accountable, then this high victim blame is reduced, and reduced to the level of those participants who scored low in female precipitation beliefs. So I would say moderately successful approach to promote data-driven processing. So by way of a summary of this second part of our studies, making Me Too salient did not affect perceptions of rape. The posters were completely ineffective in raising awareness of the need to obtain sexual consent. The written reminder in the form of this consent paragraph was also ineffective, as was the combination of both. The impact of rape myth acceptance on case judgments may be reduced by introducing accountability, especially in cases that deviate from the real rape stereotype and in participants high on rape myth acceptance. And I'm happy to speculate about the possible implementation of this strategy in the legal system. Some limitations, of course. First of all the research that I've been talking about focuses on female victims of sexual assault. Studies on male rape myth are limited, but of course there are also myths about men as victims. For example, the very broad myths that men cannot be forced to have sex against their will. So there are some studies now identifying the content of these male rape myths that show some overlap with female rape myth, but are not identical. And there's also increasing evidence that rape stereotypes also influence judgments about male victims of sexual assault. Then all the material is based on vignette studies that are very limited in the detail that they present about the cases. But the advantage is that we can systematically manipulate the critical variables while holding other features constant, which trial observations cannot do. And our findings converge with the findings of studies using other methods like trial simulations and trial observations. Participants, of course, are aware that judgments do not have real consequences, but research with real juries is not permitted. So there's no way in which this limitation can be addressed, I would say. Yeah, my final question or final thoughts that I would like to share with you is to do with banning rape stereotypes from the courtroom, which I would say is a daunting task, and progress is a snail in this area. Is it possible to ban questions about victim sexual behavior or character? Yes, in theory. There's rape shield legislation. There are sections prohibiting inadmissible character evidence, but this information is often introduced by defense lawyers, even today, even in the presence of these legal regulations. They are often left to pass by judges, as trial observations show. And once the information has been presented, again, social cognition research tells us that people cannot ignore it. So that's has not been very successful so far. More female staff in police and judiciary, that's always an easy to make demand, but research shows that attitudes are much more important than gender. That will not solve the problem. Screening for rape myth acceptance of jurors, judges might be a possibility. Problem here is we do not have instruments that are usable for individual diagnosis, if you like. There is a parallel situation where you have death qualified juries where you eliminate potential jurors who are opposed to the death penalty on principle grounds, but we have no such thing for rape myth acceptance. Allowing expert evidence in rape cases that might explain, for example, that traumatized victims do not show emotional agitation when they talk about their trauma, might be a possibility. Certainly in non-adversarial justice system, if you have an adversarial justice system, you always have two experts, one from the prosecution and one from the defense. And whether or not this opposing expert evidence will be beneficial to reducing stereotypes is an open question with a big question mark. Message in my last 24 seconds. Clear evidence that judgments about sexual assault cases are influenced by general stereotypes about rape, and extra legal information that has nothing to do with the legal definition of the crime about victim-perpetrator relationship or type of coercive strategy does affect perceptions of victim and perpetrator blame. The key goal, I'd say, is to promote data-driven processing, and the results demonstrate the need for theory-based interventions, the results from the poster study. Good intentions are not enough. They may even backfire, be counterproductive. And I think this is a particularly fruitful area for collaboration between social cognition researchers, aggression researchers, of course, legal scholars, and policymakers. My final word goes to, as a big thank you to my collaborators, Jennifer Temkin, Anja Berger, whom I've seen here tonight on the list of participants, Shira Malayeri, Christa Nata, Franziska Saxler, and Sabine Chesney from Switzerland, and of course to you. Thank you very much for your attention. And I look forward to your questions and comments. Thank you.
Thank you so much. That was so good.